Y'all know what it is, man. New Culture Empire, man. SETU, Supreme Elite Team, man. Getting it. February, the new Supreme Elite Team University is launching. Y'all tap in. It's a new year. We are off to a blazing start on this new year, 2026. We are off to a blazing start already. Off to a blazing start. Update. K, Ohio, case update. We will be moving for summary judgment. The Velocity has been reaching out to my client. They want to discuss resolving the matter. I think we'll be getting on the phone with them tomorrow. They want to resolve the matter now. 2. UWM, we filed our response to the foreclosure, and in the next couple weeks, we have a status call, a contested call. UWM did not get the automatic judgment. Foreclosure, they didn't get the judgment. My case, credit acceptance has failed to make an appearance or respond. So any fraudulent defects related to the service, which service was perfected, they have waived it by not making an appearance or requesting an extension. And this was as of the close of business, January 2nd. And they still have not made an appearance. As of yet, Monday, I will be moving for entry of judgment. See, this is the procedural missteps that a lot of people do, pro se. They'll move for a default judgment. I've seen plenty of people open the door back up to the other side because they move for default judgment instead of requesting the entry of judgment by the clerk, according to Federal Rules of Civil Procedure, Rule 55. Once the clerk issues the entry of judgment, then you motion the judge for default judgment. It's at this time is where credit acceptance usually pops up with a motion under Rule 55C or 60B. The problem with them is they have to show good cause why they never made an appearance, whether it's internal routing delays, it's a large corporation, we was waiting for a lawyer to take the case, yada, 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 yada. The problem that they have getting around the good cause shown is they sent me a letter September 8th, already aware that I filed a lawsuit against them and said, hey, you filed, but you haven't served this yet. Oh, Your Honor, he didn't service at our registered agent. There's a controlling case out the Fourth Circuit. Actual notice satisfies the service requirement. I served you at the address where you sent a communication from me, in which in that communication, you were aware that I filed the lawsuit. You told me I filed the lawsuit. It was addressed to the legal department. You knew, you was aware, and you received actual service. So that kills your potential Rule 55C or Rule 60B arguments. Those are only 2 rules that I found which they could try to come through the back door. So we have a non-appearance in one case. We have a summary judgment moving in another case, and we have a contested cause status hearing, non-judgment granted to the moving party in third case. What is the common denominator in most of these cases? In 2 out of the 3 cases, there's a few of them. We're going to walk them down.
I say you're wrong in the house. I say you're wrong in the in your mind.
As we start 2026 out, we're going to walk these denominators down. Two cases. Complaint filed. We're ordered to respond. We respond. No summary judgment. I mean, they didn't even attempt to type it up. They ain't even draft one. That's a common denominator. Why is that? Why do I have to point this out?
Why are you doing this?
It's because in 98 to 99% of the cases where pro se litigants, after they respond, the other party most definitely moves for summary judgment. Bam. And in many cases is granted. Boom. That's a common denominator. Another common denominator. In 2 out of the 3 cases, a complaint was attached to their filings, meaning it was a debt. It was a consolidated debt, had the promissory note, had the debt, and the other, you had the promissory note, the deed of trust, evidencing a substantial amount of debt. The common denominator there is, even with the evidence of debt filed with the case, they still didn't get immediate judgment. To acknowledge that. In all cases, the common denominators are, as soon as we respond or initiate, one thing that you notice, all 3 adverse parties tends to fizzle out or stay silent.
You're rocking with the best.
Another thing to look at is, these are all 3 separate cases. You got an auto case here, you got a mortgage case here, you got a consolidated debt case over there. 3 different distinct cases, 3 different elements, 3 different causes of actions, but you are seeing the same and similar results. So with that being said, 2026 is starting off on the right foot for the most part. And what's being taught in the group is being directly manifested and the outcomes. Now, one thing that you still have to account for, and I'm still going to account for, is we still don't have the final say on outcomes. I want people to still understand that I can't guarantee an outcome. Yes, filing a lawsuit is a risk. Yes, you are taking a risk when you file a lawsuit. Yes, you are taking a risk when you step in court. Because, I mean, one thing about court, which is very easy to comprehend, court is either going to be a winner or a loser. It's either going to be a winner or a loser. There's no in between with that. Either somebody's going to win and somebody's going to lose. We aim to be on the winning side, but I'm also not foolish enough to have the mindset that we're going to win them all. Hell, if we end up winning them all, that's perfect, but I'm not going to approach it like it's a slam dunk win. Court has their own tricky ways of operating. Sometimes in court, things play out totally different than what you anticipate. And it's in those moments that you have to adjust. Prime example with the UWN case. Let me see, April, May, June, July, August, September, October. We had to play defensive for 9 months. Of course, we like to be on the offensive, but we had to stay in the defensive for 9 months, damn near a whole year. We had to fight this battle on the defensive. And we had to make strategic moves within those 9 months. We didn't agree on every course of action. It's life. But we had to fight this case and stage off the judgment for 9 months. Now we're in the position to get on the offensive. Like I said, when you're coming in as on the defense, you cannot argue your case as if you're coming in as the plaintiff. Your arguments have to be different. You're a lightweight. You're a little restricted in your arguments because the plaintiff controls the venue. The plaintiff just may be suing for non-payment of debt. You can't get off in the tangent of financing and accounting. Like, you kind of got to stay in with the facts of why should they not be entitled to this debt. Can't get into all that other stuff because those are usually reserved for plaintiffs. That means you have to survive the initial stages so you could come in as the counter plaintiff and counter sue. But the hardest part in any court proceeding, y'all, is the initial stage. It is the hardest part. But it gets harder if you don't understand court rules and procedures as the case proceeds. Rules of evidence, discovery, subpoenas, all those in-between motions to compel discovery, staging off summary judgments, bringing countersuits, quiet titles. All of those things can come about after the initial stage. So how I look at it is I don't even think about any other stage of the proceeding until we get past the initial stage. That's the number. As a plaintiff, passing the court sufficiency tests. As a defendant, staging off the immediate judgment or summary judgment. Now, here's the thing that I want to highlight to you. It is very common for these lawyers to most automatically move for summary judgment regardless. I mean, it's now become just a formality to them to move for summary judgment right after you respond. And it's not even a 50-50 case. Like, it could be, hey, we got about 20-30% chance. It doesn't hurt them. You know, all the judge is going to do is either just deny and schedule a conference or, a trial date. I mean, it doesn't hurt. Okay, so let me show you a difference of a real party of interest. So this is the response we filed to the mortgage. This is the response we filed, in which got us to the next stage. Told y'all, man, I'm telling you. Listen, when it comes to consumer litigation, I'm telling y'all, tap in. I'm telling you, I'm a dog. I don't work for free. But you're going to get, when I'm done with the motion or the complaint or whatever we doing, I guarantee you're going to be 100% satisfied. I guarantee you, if you're not 100% satisfied after reading the whole response I put together, a complaint, I guarantee you on my soul, my great-grandmother, I'll give you all your money back and you can keep the document. Now watch this. Defendant admits, look at this. Defendant admits that he executed a note and mortgage related to the subject property. However, defendant denies that plaintiff or that there is a difference. Most people want to deny the fact that they signed the note. So this is when you start playing stupid with the courts. You signed it. You know you signed it. No denying it. That makes your position weak when you don't even admit to the obvious. Yeah, I signed it. That's not the issue. Defendant demands strict proof as required under Illinois law. Defendant denies that plaintiff has not, as required by 2012, is insufficient to establish standing without credible evidence of. This is right at the tail end right there. But this is one of the secrets that never was overturned.
You're rocking with the best.
Everybody's talking about chain of assignment. Chain of assignment. I told you, people just follow the wave. Everybody wants to talk about the chain of assignment, chain of title, chain of assignment. I could give two facts about the chain of assignment without me talking about. See, that it's so, it may seem so insignificant, but it's the difference between them moving for summary judgment or not. It's the difference between winning your case or losing your case at the beginning stages. Whether you win or lose your case at the beginning stages is always going to be based on the little things. It's always going to be on I told y'all, it's not the Big Bang theories. It's the little things. Defendant lacks sufficient information to admit or deny the remaining allegations and therefore denies them and demands strict proof therefore. Defendant denies all remaining allegations not expressly admitted. Illinois requires that every action be prosecuted. In foreclosure cases, this means the plaintiff must possess. Plaintiff, UWM, has the February 2024 debt validation response admits, however, the foreclosure complaint filed by UWM. And one of the common things that you're always going to notice about me, I always use
Gotcha, bitch.
against them. I use
Gotcha, bitch.
against them. Credit acceptance was smart. As soon as they started to see that, they stopped responding. Illinois courts requires, and this is what 99.99% of people in the world don't get. They always let these people off the hook. They're so worried about arguments that they believe is true instead of knowing what arguments in court insisted on the same issues as yours, and you start your arguments there. But since the guru has 40, 50,000 subscribers and followers, what they're saying out their mouths must be true. And if they're saying there's no case law that exists for accounting, oh, then it must be true. Right. No, that's just the guru you chose to follow. They chose to follow gurus who doesn't have the necessary understanding to help those people get the results that they're looking for, because both of their mindsets are on the same level. Can you imagine any of those people signing up for a securitization 6-hour course, paying $4,000 for 6 hours? Can you imagine can you imagine who's in that room? Can you imagine any of these people in these spaces in that room? Oh, no, they're not going to look at the $4,000 as an investment. Because remember, they're going to look at it like, shit, why am I pay $4,000 for this securitization course taught by professionals when I can pay $99 for the girl Facebook and I get that one there? And this is why they get lowball outcomes. If you think anyone's going to come into this space, these spaces, especially in 2026, how real it's about to get, tackling accounting, securitization, securities law, applying it to court, investor laws, and you think you're going to get a low ball quote for it? Shit. Holding that UWM never expected us to come at this angle stopped them dead in their tracks with this response. I know they was itching to file for summary judgment. So instead of summary judgment, we got a phone conference, a contested call hearing, which decide what's the next steps. Hey, we're going to do trial. We're going to do discovery. What's going on? Because one thing that's common denominator, they filed the complaint. They had the note. They had the mortgage. We responded. No immediate judgment. And if you look at these gurus online today, guess what they're always highlighting when they come online talking about their client's case? It's always on appeal. Y'all notice that, right? It's always on appeal. It's always after they lost. It's always on appeal. Let's be honest. Let me ask y'all a question. When have y'all seen any of these gurus online come on court, come online, whatever they're doing, at this stage where they responded and there was no immediate judgment for the other side?
Part of me is telling me to give up, but the other part of me is telling me to keep going.
When you ever see it?
Never.
It's always, oh, we on appeal. They always got to go on appeal. I mean, every single one of them lost in the beginning. This defect cannot be cured by, we haven't been saying for months. And they better make sure they got all their ducks in a row, because right there they lost their case. How we do it over here, they lost their mortgage complaint. Damn, ain't that something? They lost it right there. We just playing, letting the procedure play out. They lost their case right here at this stage.
Gotcha, bitch.
Yeah.
So just imagine if any of those gurus just got their hands on just this particular argument.
Oh my gosh, bro.
Just this argument.
Oh my gosh, bro. They would be resurrected. And you know what? I'm going to clip this section up and I'm going to mute it out and I'm going to block it and I'm going to make sure it's the only thing you hear is, just imagine if they got their hands on this particular argument right here. But I'm going to blur the whole screen out.
Yeah, but I get ready to say, please don't.
I blur it out. They won't even know me. I love doing that because they not know to send me, hey, we can't see. You keep blurring out it. Duh. You ain't paid to be in my group. You wasn't with me when I was shooting in the gym. You ain't part of the Supreme Elite team.
You're rocking with the best.
I told them, I don't go online to teach people the right way. I go online to tell them everything they're doing is wrong.
Emotional, damn it.
I don't teach online no more. No, I'm not teaching this online. You're either going to be in my private groups or all I'm doing is say you're wrong. Because I don't have to prove to them that we're right. Y'all get what I'm saying? I don't have to prove to them that we're right.
Yeah, we got one in Georgia. That's a credit card. And Lamont went over it, I think it was a couple of weeks ago, and we hit him with the same thing. Hell, he ain't filed an opposition appearance or anything.
Well, thank you very much.
We just waiting on 26th of this month for the oral argument, and that'll be
Hold on, bro. Hold on. Listen. Look at that. Hold on. I don't want you to miss it. You probably didn't. I just want to make sure you don't miss it.
And
you survived the initial stage.
Yeah, I'll send it to you. I'll actually text it to you because
man, you're supposed to mention that to me.
Hey, I'm waiting on my cousin to win it. That way he can do audio so you can play it.
Oh, but, okay. Okay.
We know he done beat it because we pulled that law, and it was supposed he just filed some payments, so he done.
Hey. Yeah. You see what I'm saying?
Rocking with the best.
See, with the Supreme Elite Team group, you get the things that you need to win your case.
Rocking with the best.
Now, I don't know about this, where he got that part, where he figured out on his own, or it was from what was in this group. But if it was, you see what I'm saying?
No, it's from the group.
Oh, you're rocking with the best. You're rocking with the best.
You see what I'm saying?
When they filed it just like you said, and they went for summary judgment. I'll send the documents to you. They went for summary judgment. Boom, it got stopped with a motion. They gave him a court date to hear the motion. it's been over a month now. That lawyer, he won't even respond. He won't even respond to the emails.
When you see all the receipts that I drop on a daily basis, all the progress in these court cases, what makes you think anything over here in the Supreme Elite team is misinformation?
Yep, told you. And for those who's going to be hearing this video later, it's not just me. It's not just me. Because y'all know it's very suspicious when everybody, the only ones who always seems to get remedy is the teacher. Never, I mean, not even like nothing trending positive for the students. Like me and Wes. It's like he the only one that seems to get it right and everybody else doing it wrong. Right.
See, I text you the description too, oral argument for
Bet.
motion. So that lawyer, he hasn't responded because that's everything going
Rocking
on in
with
the case.
the best.
Yep.
He just ignoring them now.
Of course. And that's what they do. Yep. So it's a tricky thing. When 90% of the time, if you argue it right, they've already lost.
You're rocking with the best.
And this is not just what I'm saying. It's the same thing with the Ohio case of my client with the debt buyer. It's the same thing in this case. It's going to be the same thing worldwide in 90% of the cases. When they file a complaint, there are one standing is to actually go into the courthouse office and file the suit. I mean, anybody can do that. The other standing must be all the elements made. But I get what he was saying now. Yo, they all make these same mistakes. They all make these same mistakes. Every single one of them makes these same mistakes. Every single one of them.
That's a fact, man.
They all make the same mistakes.
I haven't seen one different. I've
Not
seen
one. Not
every last
one.
one. Every last one.
Midland, Synchrony, this bank,
Everybody.
mortgage, auto, they
Everybody.
all, it's all, I was like, yo, all of them. I don't care what the situation is. I guarantee you, I see that it's always a defect. Right there. It's always one, especially in mortgages. Man, they so bad with mortgages. None of them. None of them. Mortgages is the most trickiest to win, but low key, they're some of the most easiest to win because none of them. Want to know why? Because there's always going to be.
You're rocking with the best.
There's always going to be. It's never going to be. Want to know why? Because it's never. They'll be lying.
Nuclear bomb, boom.
Damn. They know that. So they.
You're rocking with the best.
Man,
Yeah,
y'all.
these guys that we got, they out of Plantation, Florida, representing City Bank. And then when I looked at it, I told my cousin, I was like, man, you don't even have to bother Thomas for this. It's actually 3 attorneys. One is a Jewish attorney, and they just ignored. They just went flat quiet.
Now, that's what they do. That's what they do. I swear to God, if they had something, they have a whole lot to say. That's what they do, broski. That's what they do. I love it when they get silent, especially when they was talking a lot in the beginning.
That cousin of mine, he was like, man, I'm saving my money. Let your guy know I'll be in the classes soon.
You're rocking with the best.
I mean, you know, hey, tell them to pull up. Only thing it's going to do is help them get to the elite level. Now, y'all, I don't look at myself as being at the elite level yet for the sole purpose that I don't have the years in. Now, if I get down to I'm at 12, this would be like year 13, 7 more years that I would consider myself elite. I would consider myself elite, but it's just the years. It's just a years thing.
Now he admit, man, he said that I never heard of this stuff in my life. He said if I knew this, man, I wouldn't have paid my last 3. He said I was paying on them, and they
You
all
see what I'm
took me to
saying?
court, and I settled out of court. Never heard of this before.
See what I'm saying? See what I'm saying? But this is not it's not
You're rocking
uncommon
with
for a
the
lot of people though.
best.
Listen, man, I used to think that the attorney was just, jerking my chain when he said like less than 10% of attorneys even know this. I said, that might be a stretch what he was saying. I was like, but what kind of made it real to me is when my recent client, she is an attorney and she has a background in securitization. And she didn't even know none of this. I said, this has to go on appeal, all controlling cases on appeal. Cannot foreclose because the court dismissed the action. A plaintiff in a mortgage foreclosure, and that is the one key missing link that many people don't, lawyers or mortgage people don't know it exists, and they can't differentiate between, and they don't know the elements that's needed to disclaim. Let's read along. UWM acting has shown that's all. Therefore, UWM has no right to bring this foreclosure action under Illinois law. It's fatally defective and should be dismissed. Now, this is all based on the facts and evidence gathered in this case. Every case is going to be, I told you, in my book, I argue everybody's cases differently. I don't argue cases based on the general script and template. I mean, the rules and evidence are probably going to be the same with all. Might probably different variations, but with me, I'm going to argue every case based on each case facts and circumstances. So that's why I say like each outcome is going to be determined by each facts, each case, me consulting the rules of the court, me consulting the procedures, me consulting things in that nature. Defendant argues the Illinois Supreme Court held it's designed to prevent litigants from by taking contradictory positions for personal advantage. Now, the Fourth Circuit has cited that same term. I don't give a damn what state you in. They're always going to have this right here, judicial estoppel.
No pressure, nah, I ain't feeling no pressure.
You're rocking with the best.
With the street code, I abide by to the letter. It's just me against me, I ain't feeling no pressure. There's no hoes barred with the shit, nigga, everything gon' go. Hoes come to see me, I miss a heart.
You're rocking with the best. You're rocking with the best.
What's going on, Supreme Elite Team, the new culture empire? What you just heard was a sneak peek of what goes down in the Supreme Elite Team. Just a sneak peek. If you can imagine how many videos do we have just breaking down from the corporate level, attaching pretty much word for word case laws where the courts are confirming what we're saying. Now, why is that important? The reason why it's important is because when you have the courts and their case law and their prior decisions confirming what you're saying, the chance of you of succeeding goes extremely high, and the chances of them winning on the judgment or even attempting to move for summary judgment is slim to none. Every case in 2025, besides my own, I was the only plaintiff in my own case, which is, it's understandably so. Every other case, the other side was the plaintiff. My clients were the defendant. Out of every case initiated in 2025, from the time they came to me,
No, I have one more case that was they're the plaintiffs. I have one more case. But one thing that I can rest assured to say, and not lying, because unlike all these other gurus, I actually drop videos of what's going on in the case. I may drop them in a short on YouTube, TikTok, Instagram at the New Culture Empire, so you can have a visual to see what I'm talking, because I wanted to separate myself from the rest. And what the rest of them do is they'll come online and just drop a screenshot, drop something that catch people's attention, and start teaching from that screenshot. What I do is I teach from case law, court cases that's already decided the same issues that we're bringing. Number one, I teach from professionals, professors. Like, I teach from the system in which it's customary and it's recognized in the system. What you'll see from these other gurus is they'll put their own beliefs and what they believe it is or how it should be. And then they'll teach that to people, and it's forcing people to impose their beliefs on a system that's already structured. One of the reasons why everything with these people is always going to be an administrative process, is because these gurus, I don't even want to call them gurus, but that's the name we'll give them. These gurus can never, ever, ever find a case that 100% substantiates the claims that they're making. And court is the standard. I know they told y'all administrative. But one thing that I'm going to tell you, and regardless if you believe it or not, anytime you send something to a legal department, their response and how they interact with you is all going to be predicated on whether there's any threat of you getting your rights enforced in court or you succeeding in court. That if they don't feel that there's any threat of that happening, they're going to steamroll right over top of you, and they're not going to take your claim serious, because contrary to popular belief, whether it's administrative or not, like I said, administrative or not, the courtroom is the standard to determine whether your claim has merit or not. An administrative process is not the end all be all. An administrative process is nothing more than a final attempt to resolve the matter outside of court before you take it there. So an administrative process, it's like, let's resolve this administratively. Or if there's an issue that doesn't really need court intervention, it's like you can file, like you can appeal the administrative decision and take it from there. One key issue that I want to bring up is even the IRS tells you, hey, if you disagree with this, you can file a suit in the United States District Court or the tax court. So they're telling you, if you disagree with this administrative decision, then you can take us to court. So what I'm basically trying to tell you is, you don't even smell a mortgage, a satisfaction of lien. You don't even smell one of these unless whatever's sent to them, it got their attention and they knew there was a substantial chance that they would lose in court on the arguments. So although administrative is a good way to save time and resources, when you're talking about all these claims people are talking about, mine included, there's only one venue that will determine who's right, who's wrong. And that venue is court. I don't care if you send the Dead Sea Scrolls to these people. If you cannot prove that you can succeed in court on the arguments, they are not going to acquiesce. And they damn sure are not going to remove you off auto pay. They're not going to cease collections unless what you sent to them had court enforcement. And let's say this, not only court enforcement, but case law to support your position. That's what's missing in all of these administrative claims. Case law to support their position, stating, hey, if you don't resolve this here and I take you to court, I'm likely to succeed, because if you look here, same elements, same facts, same circumstances. I've yet to see, and I put a challenge out. And let me tell you that I put a challenge out. To, I forgot their name, and I'm not even going to say their name anyway. They're a teacher on TikTok. And they said, so what? They do that all the time. Credit acceptance. He said they do that all the time. So he said, well, I think it was he. I'm not sure. I assumed it was he. So they said, once you send your documents to them, they're going to do that regardless, automatically. I said, cool. So all I said was, can you produce a situation with CAC in which, before you filed a lawsuit, let's take the court out for 2 seconds. You sent them your accounting claims, your consumer law claims, your security claims, all three highly complex situations, and then back it all up with court precedents, and then a document breaking down their past 5 years of what they reported from an accounting standpoint, income, and then pinpointed that they may have underreported $190 million in income by misclassification, the items of income, and a whole full whistleblower report that you sent to them. All I asked was, okay, if they do it all the time, then show me from your own work, from your own hands, that the same thing that happened to me happened to you. And I'm still waiting. No response from that day. It was going back and forth as long as there was a dialogue. But as soon as I say, okay, you know what, let's end the talk. Here's proof when I'm talking about I'm correct. Where's yours? All of them go away. All of them go away. No. In 2026, I don't care what teacher you are, what guru you are. I'm going to hold everything you're saying under the judicial light. I'm going to hold everything you're teaching under the judicial light. And there better not be case law in which the courts have rejected the same arguments that you're now making. There was a person today, and this is what, and I'm only doing this to highlight how valuable the Supreme Elite Team University is going to be. There was a person today that was citing 18 USC Section 8 and 31 USC Section 3123. Now, I know they didn't read the public law, which established those statutes. No, they never get the full context. So he's saying you can use those two to get out of debt or get your money back. This is on Facebook. Actually, I'm gonna tell y'all the name. I'm gonna tell y'all the name on Facebook. It was teen it's okay. It's okay. I know. Y'all always do it. I know. Yep. Y'all always do it. Yep. Y'all always do it. I know. Yep. But yeah, broke my Xbox. I know. So let me go back. Let me go here. So what is the name? The name was, I'm sorry, y'all. I forgot. It's teen thing something. So he was cited 18 USC Section 8 and 31 USC Section 3123. Regardless of the fact that 18 USC is a criminal statute in which the government uses to prosecute people. Now, let's just break that down for a second. Forget belief. Forget because you read it on those confirmation bias websites. Forget that you saw it in a document on Scribd. Forget all that. Forget that they just keep throwing it in your face like it's true. Forget all. Put that to the side. We're going to speak simple logic. And that's all I ask people is just to use logic. Just like you ain't even got to follow me. You ain't even got to believe what I'm saying. You ain't even got to believe in my receipts. You ain't even got to believe in client testimonies. You ain't got to believe in the fact that none of them has gotten a direct judgment when I step in the picture. You ain't got to believe none of that, even though all the evidence is clear. You ain't got to believe none of that. Just think. Title 18 USC is under the chapter Crimes and Punishment. And this is what federal prosecutors use to prosecute people who violated statutes under Title 18. So that's their thing right there. What in anybody's right mind thinks that Title 18, which is solely reserved for federal prosecutors, can be used as a cause of action in a consumer transaction? Like, let's crimes and punishment under Title 18, cause of actions for a consumer. Please, someone tell me from a legal logical standpoint how that connects. And that's what the Supreme Elite Team and the Supreme Elite Team University is going to do for people. It's going to get everybody just back to the basics, because many people out here, they focus so much on doing, submitting documents, doing, that they never laid a proper legal solid foundation of understanding, so they understand what they're doing. So everything they do is going to be judged under judicial light. It's not based on, I believe it's true, I want it to be true, what everybody else is saying is true. No, you're going to understand the reality of the system. You're going to understand how the system actually operates, and how the system operates may be totally contrast from how people believe it operates. Clip that. And regardless of what listen, like I said, I have no personal opinion about the system, because my opinion about the system doesn't matter. Do I think there's better ways of how the finance company should go about things where they're still making money, but the borrowers are still left in a better position? Yes. But my opinion does not matter. How I believe the system works doesn't matter. I follow the system on how it operates today and what's accepted. So if I'm saying, everybody, you should be going this way, and you got this person saying, hey, nah, y'all should be going this way, and then you got this person saying, nah, we should be going straight ahead, and I'm the one that says, nah, y'all, we should be going this way, because look here, look at me, look at my clients, look at my other clients, look at my group. So I think y'all should be going this way. But you got the other two saying, nah, don't go this way. Don't go his way. Go my way. But they have nothing to, well, can't show no personal results. Can't show results of clients. So now so you got the other two just telling you it's the right way, where I'm showing you it's the right way. And this is where beliefs, feelings, whether you like a person or not, has to get thrown out the window, because obviously I'm assuming you want the job done, not just to be right. And I think people get lost in why are we really like, why argue me down? The question is, why would anyone argue me down if I'm saying no? The accounting that these people are trying to apply, they're going to ignore it and override it because they know you don't truly understand what it is. They know you don't know how to connect it back to the consumer side. And I'm saying, they're not going to respect it. And I'm saying they respected mine. So I'm telling you, I know what I'm talking about. They respected mine and they didn't want to, but they had to. I know what I'm talking about. And people will still argue me down. And this is what happens when you hear things that you don't want to hear. People are looking at it from the wrong mindset. Let's just be 100% honest and clear. It's not a secret I'm connected to some very powerful top professionals. Like it's nothing for me to figure out the right way. Like literally, it's nothing. Hell, it's a text. It's a text. As a matter of fact, it's nothing more than a phone call away. It's nothing more than a phone call away. It's a text to get access to the top professionals in the world. So it's not really about that. But the thing that I'm trying to figure out and I'm trying to understand is, what is it more about to you? Troy, what's going on, broski? I know, hey, I know tomorrow we got to get back on the line. I know I seen the message. My phone was down for a couple of days, but I know we got to get back on the line. I know you done met up with the head honchos.
Yeah, I had a video conference with her. I didn't get to do it face to face.
Oh, that's perfect. That's perfect. That's still good. Oh, that's perfect. Oh, that's perfect. Woo-wee.
I've got to go with a buddy of mine tomorrow. He's got a trial in the morning, but I will get a hold of you probably around about 2 or 3.
Perfect.
And we'll start looking at the university thing, planning things out, whatever you need to do.
Yep. Yes, sir. Yes, sir. We get and putting the finishing touches on the university. Yes, sir. I appreciate you.
Okay.
All right. All right. See you tomorrow.
All right, bud.
All right.
Bye-bye.
You're rocking with the best.
That video conference we talking about, that person, one of the best of the best to ever do. You wouldn't even believe me if I told you who that person worked for. You wouldn't even believe me. You wouldn't believe, well, how the hell you get? You wouldn't even believe me. You wouldn't even believe me. And this person I was on the phone with, this person fact checks me daily. This person fact checks me daily. He's been fact checking me for like a year and a half, and I didn't even know I was being fact checked. Once I started talking about accounting, securitization, securities, his friend used to work for the SEC for 27 years. The SEC is the watchdog over all these transactions. So if I was wrong, oh man, woo-wee. I guarantee you, if I was one of these other gurus, oh, he'd have been put their ass on blast. Because he can easily get it confirmed. Let me tell you how direct access I have. It's nothing more than a text. It's a text. Hey, yo, I'm going on this. Hey, yo, this is the situation. I want to take the group. Yo, ask the attorney, is this, am I off or am I right here? I think I'm right. I think that's the way we should be going. Oh, yeah, I just reached out to Betty, got back to me, say that is absolutely the way you should be going. You are 100% correct. Keep going. So to me, it's not about the information anymore, not on my end. But I know people are punch drunk and shell shocked because they tried this, 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 they tried this. But you want to know what causes people to try all those things? I'm gonna tell you what causes people to try all those things. When you never really had a full foundation of understanding of what's going on. See, once you have a full understanding of what's going on, you already know, nah, that damn sure ain't gonna work. You're not even gonna go down that road to try. Because the more you spend money with people and the more you get disappointed, people naturally tend to think that anybody that's teaching this stuff is all after the same thing, which I understand. But the problem that I see, especially with students, is not only do y'all give people your hard-earned money, these gurus, y'all give them y'all spirit and y'all will and y'all drive. It's like they suck everything from you. Now, here's the thing. Well, he says, no one will challenge you because no one has any real success. Okay, that's true, right? I give you that. To this day, no one has ever came out and said, yo, what you're teaching is inaccurate. And I put myself the challenge. Anyone who's saying what I'm talking about is inaccurate, I swear to God, all you got to do is send me an email and I will line up a live stream with you and you can come on stage and you can tell me where I'm wrong about accounting, where I'm wrong about financing, where I'm wrong about securitization, where I'm wrong about court law, case law. Anyone can do that. It's hard to do it because I don't come online and be like, here y'all, here y'all, here y'all. Those are reserved for my groups. But in any event, it's not, to me, I'm beyond the stage of trying to tell people I'm right. I'm beyond that stage because this is not nobody but me. This is my personal situation. This is mine. This is mine. This is not a client. This is mine. So I'm utilizing the same things I teach. And the benefits of me understanding has allowed me, what was it? Been 6 months now with money that would have went to an auto payment, $622.96 a month at that. So let's hold on. Let me just break it. Let me break it down in tangible for you. So $622.96. How many months we July, August, September, totally remember it. Let's say 6 months. Times 6. So I was able to save $3,737.76, all based off understanding.
You're rocking with the best.
My clients with UWM, a $800,000 plus mortgage, are now in the position, we're finally in the position now where we're going on the offensive and they can end up with clear free title to the home, all based off understanding. I'm not going to say my because we're doing that as a team. All based off understanding. See, investing in understanding is always an investment for the future. Yes, I had to pay my dues. I had to pay to get into some top secret classes. I had to come out. I had to pay my dues. Nobody is around paying their dues. Most people want the top elite level knowledge at a bargain. And in the real world, you don't get that. $378,000 here all from understanding. So the benefits of understanding actually saves you in the future. But the biggest problem that most people are going to have is that instead of uprooting everything that they thought they knew and coming with an objective mind and just admitting that, hey, maybe I didn't know what I thought I knew. They're not going to do that because most people, they just don't want to be wrong or don't want to give people the benefit of saying that they're wrong. When you're first starting out trying to learn this stuff, you're going to be wrong more times than you're right in the beginning. Oh, let's just get that clear. That's life. The losses, wins or losses are all part of the same game. As a fact, you learn more from your losses, which can convert into more future wins if you understand the lesson in the loss. See, there's always a lesson in the loss. When people lose, first thing they do is sulk and go, oh, it wasn't done right. Oh, you know what you're talking about. But they don't understand the true lesson. Prime reason. The courts, whenever they're denying a claim, they actually tell everybody else how to win. I've tightened up my understanding way more by reading cases where people lost more than where people win. Because remember, a smart man learns from his mistakes. A wise man learns from the mistakes of others.
You're rocking with the best.
So when I look at these spaces, I look at these spaces as a case study. No, I really study the people's mindset in these spaces, the stuff these gurus are teaching. I use them as a case study for my group. So I use these people in these spaces, the students, the teachers, the ones who come in my videos after it's posted and comment like they understand it all. I use them just to come to my people and say, yeah, see what we're trying to avoid? Look at them. Look how lost they are. Look how all of them are following down those rabbit holes. You see what we're avoiding by understanding and being patient and taking your time and having dedication and finding a drive that's more than just getting out of a bill. You can tell when someone is just doing this to get out of a bill because they'll try anything. They will try anything, any process. The more desperate they get, the more they're going to shoot out there. You know, the mindset, I'm just going to throw everything out there and hoping one sticks. See, with understanding with the Supreme Elite Team University, we don't even have to go through that phase. Oh, I know it's a traumatic, stressful when you're just throwing this out there, throwing all the stuff out there, and you don't even understand nothing that you're sending. You really don't even believe in anything that you're sending. You're just trying it because life has happened, and now life is starting to make decisions for you. See, with the Supreme Elite Team University, it's not about just a bill. It's not about a mortgage. It's not about an auto. It's not about a credit card. It's not about a debt. It's about renewing your mind. It's about changing your mindset so it can last you a lifetime. Prime example, you heard it in the video. There was a guy in the video in my group. He's in the video, and him and his partner had their case. They implemented the teachings in my group. Now they about to get a victory.
You're rocking with the best.
The teacher is only as successful as his students. If I was just the only one time and time again that is coming with receipts, I'm not an effective teacher. An effective teacher takes their success and it spills over into the success of their students. Another guy in my group, and I don't even teach credit repair and clean up your credit. I don't even teach that. I think that pretty much speaks for itself. He was able to use the teachings from my group to attack his credit and ran his credit up to 700 inside of 30 days just based off the teachings in my group. And I don't even teach directly like credit. But all the information, the gems, you can take those and create your own situation wherever you want. So to really be honest with you, I can't even put a price tag on this group. And then we're infusing the curriculum with the top professionals, the stuff that they study, the stuff that they read. And it's a coincidence that I read a lot of the same stuff. I'm already reading a lot of the same stuff that the attorney said, nah, y'all should read this. I was like, damn, I already have that book. Oh shit. I'm really on the right track. But there's always going to be problems. There's always going to be haters. There's always going to be detractors. And I feel for them because it's not like, this is what I believe. I don't believe people are taking a negative disposition because they just don't like you. I think they take a negative disposition because they secretly admire. Like some people wish they had that strong of a willpower to sit down and break through and understand the highly complex nature of this stuff. Started in federal prison, self-taught all the way through, and to be able to come today and say, yo, you got it out the mud. Trial and error, yes. Had to learn from my mistakes, yes. Had to lick my wounds, yes. But to be as dedicated as long as I have been to research in details and attention and court, administrative, finance, corporate finance, to be able to cover that, those multiple different topics, and the confidence and the assurance, a lot of people envy that. I mean, they can't come out and say what I'm talking about is wrong. I mean, this right alone shuts everybody down because none of these gurus can ever show a successful mortgage. I mean, they can all talk about it. I hear them talking that they can do it, but they never show. And we all know what's the number one market employee that you can use that say that you know what you're talking about? Your successes. They ain't nothing better to show to people. Lawyers do it. They do it all the time. Hey, we was able to secure this. Hey, 65 million back for our clients. That's what you can show. So their marketing to people is buy my stuff because you fuck with me. Buy my stuff because I believe it's true. What I'm saying is come best with join the Supreme Elite Team University because we're going to get you the real results that you seek. And as evidence, we're going to get you the real results where I see, here's a video of this. Here's a video of them not getting the judgment. Here's a video of them not getting the judgment. Here's a leaked phone call with the client. Here's a leaked phone call with my partner talk to the SEC attorney. Here's a leaked phone call with this. Here's a phone call with me on the phone with them. They're confirming what I'm saying. Like, you see what I'm saying? I never use a phone me because I'm just saying it's true. I always come and show and prove. And that is what this space has been missing for decades. And I don't blame the teachers. I blame the students. I blame the clients. Y'all have allowed these gurus to come up on these panels, come up on these platforms and just spew garbage. And none of y'all tried them. None of y'all tested them. None of y'all made sure that they knew what they were talking about. And they did that on purpose because they were looking for the desperate, financially vulnerable, and the low-hanging fruit. But they can never pull that off on someone like me or anybody in my group, because everybody that's in my group that comes to these panels, they always end up getting blocked. The wool is off my students' head. And that's the number one thing. As soon as you're in my class, you instantly are going to see how all these other teachers have been bullshitting the whole time. Now clip that.
You're rocking with the best.
We got multi-billion dollar companies remaining, running away. We got a multi-billion dollar company not even willing to make an appearance in my case. That's not because we're better. It's not because we're smarter. That's because our drive, our determination, our perseverance our work ethic is better. What separates me from any other teacher out here? My work ethic. My work ethic. That's what separates me. My drive, my determination, me staying at it. And I didn't do any of that on my own. I attracted people to me that had major connections. I'm just one man out of many teachers. Why don't they have top elite professionals on their team if what they were talking about was so legit and true? I don't have to come on here and cite 18 USC Section 8, 31 USC 3123A to get our remedy. We don't have to go that route because, to be honest with you, those two statutes, when you read the laws that were passed, none of them gave consumers any right cause of action. You can't even cite those statutes as a cause of action. You can't even cite those statutes. Now, so, okay, so look here. So let's go right here. Somebody said they responded. It looked like somebody responded to me. Let's see. Well, I thought someone responded to me, but nobody responded to me. Oh, John Martinez responded to me. So this is what John says. See, this is, I call this wasteful time of studying. It's just a waste. It means nothing in court. It means nothing administrative. But people will spend years studying things that's not going to bring them any closer to the goal because they're studying just to tell or show people how right they are, how much they know, how smart they are. Believe it or not, many people can't wait to tell people how much they know, how smart they are. If 98% of the gurus actually knew what I knew, they would be on the corner with a bullhorn solely to get praise and adulation. That's what they do. I told you, I don't even teach publicly. So I'll let you know, I don't care. Like, once you, listen, y'all, once you started tasting success and you started getting deeper in this system, you'll realize, damn, I got a bigger responsibility than I thought. There's no way you're not going to know this stuff and don't play gatekeeper. Listen, you're going to do more harm to people standing on the bullhorn, spewing this stuff off than you're doing to save them. None of this should be taught publicly. Accounting, securitization, it should all be taught in a private control setting. So you know what the attorney sent the message to me? He says, anybody that I see that's online teaching this stuff publicly, like platforms like Facebook, TikTok, Instagram, just teaching, holding classes. He said, I immediately know they don't know what they're talking about. And I believe it's true. I truly believe that if they're online talking about this stuff willy-nilly, they don't really understand what's going on. Yeah. So this person says, legal person type. Oh, hold on. There's a reply. Oh, I think he took it. Reply. So he says, look right here. Legal person type. Natural person has disability, incapacitated. That's that same old SETU V666. You're so stupid, so dumb, just because you have a name, like, which means no bona fide representative, only statutory representative, liquidator, receiver, administrated by operation of law. Although the legal person retains full legal capacity to incur liabilities and duties. Photo card is a proof of signature document, giving just enough ability to register property, but that's it. A legal person cannot revoke any waiver of rights, defense, notice, or consent if it has suffered a disability. Any relationship created by these two legal persons, whether trust, by conveyance, or by agency, by contracting a performance obligation on the transferee, which is a registered document, certificate, organizational document. It's not filed. Look, it's just a look, not paying the transfer tax. Look, bonus organ. Like, look, it's just a whole bunch of stuff, and it looks like it was from Chat GPT or some type of AI format. And what does that mean for a person that needs help with their foreclosure? Like they post, oh, interest is prepaid. Okay, what does that mean in a court case? How can I use that in my court case? What does it mean? Break it. And they never can. And this is what I mean. It's just buzzwords to get your attention. And in the end, what does it mean? And not just me, my Supreme League team members put to the side. Students of these gurus, how has 2025 worked out for you? Because we all know what y'all like to do. Y'all know when y'all get that rejection letter or get that reversal letter, y'all secretly leave through the back door and follow another teacher and don't let nobody know what's going on. Y'all like to lick your wounds in private. What has this space done for y'all in 2025 en masse? Why hasn't anybody come to me saying, my teacher got my mortgage set off? Hey, my teacher stopped my collection on my account. Hey, my teacher was able for them not to get the judgment, and they filed the complaint with the debt, with the deed, and they still ain't get the judgment. My teacher, where y'all at? Where y'all at? All I say is don't talk back and forth. Just show me. Where you at? That's all I ask. Show me. Show me. And you just get silence. It's kind of like it's taboo to have results in these spaces. You get what I'm saying? The teachers don't want it because it's going to make them put the pressure on them, show and prove. Then the students don't want to see it because they don't want to believe and admit that they've been following the wrong thing the whole time. They done spent a lot of money on it. This is now their belief system. And you know, this stuff is like a faith. You believe it's true. Can't nobody tell you no different. So it's kind of like they don't even want you to have results. Like they don't even want you to talk about it. Do you know many people, like if I'm just talking, I think it was like 3 weeks ago, I had quite a few people watching. As soon as I brought up the results, people just started leaving. Why don't people leave when I start to show results? Well, why do you leave? Is it really something within you, or is it truly the act of me substantiating what I'm talking about? Ain't that what you want? Show us what you talk about. You should know what you're talking about. But every time I show people what I'm talking about, people want to leave. Why do you leave when I show results? Why do people leave? It's not what you want to see. Or you've been so used for them just talking that you don't even know what results look like. Like, what does a remedy look like for you? And I'll tell you whether you're realistic or not. What does a remedy mean to you? Because we really got to define what is a remedy, because the word is thrown out so much. But what is a remedy to you? What is a remedy to you? What wrong are you asking to be redressed? What did they do so wrong to you? You got the contract, you signed the contract. And what do you mean unconscionable contract? Unconscionable. What does that mean? It was you, it was their representative, you signed it, you looked over it, you agreed to the terms, you made a couple payments on the account. What makes the contract unconscionable? Because these are all going to be the questions the judge is going to wonder. How is this unconscionable? You've been making payments on this account. You never brought these issues up. Now that you're being sued today, now you bring it up. What's the big issue? See, it's not just me asking these questions. The judge is going to ask you these same questions. Want to know why? Because I play videos all the time where the judge is asking these same questions. And like, where, right? And I'll take a guess. The remedy to most people is getting something and not having to pay for it. I think that's what most people think the remedy is. And this system, that couldn't be further from the truth. That it's false. There's no way you're going to acquire any goods or services in the United States and not be responsible for it. So the next thing I believe is not being held accountable for the terms that say I can foreclose in default, I can repossess in default. So the remedy to most people is, how do I get out of that? I'm not here to judge it, but I think that's what it is. What the Supreme Elite Team University offers is, once you take the university, not only in what you see what the remedy is going to change, you'll actually understand that the remedy to you, it was never what you thought it was. That's your remedy now because everybody else has told you that's what the remedy is supposed to be. You'll realize your remedy is actually more legal, more legally sound, more coherent, and you can actually substantiate it. And then you have a legal reason why you're not paying the full contractual balance. A legal reason, not a belief reason. Listen, your beliefs, my beliefs, none of that matters to the court. It's law, precedent, authoritative case law, substantiation, and that's it. It's not what we believe. So once people stop looking at the system from what they believe is true versus just what it is, I think most people will be better. But we know that 2026 Supreme Elite Team is going to end still didn't answer the question. Don't worry. None of y'all can. So the name is Alan Naji, N-A-J-I. You go on Facebook and you'll see our dialogue. So you know what the person said? A person asked me, so this person, Michael Frank, says, if you ever got a letter like this from a debt collector, send it to me here. This is a dummy letter where a third-party debt collector alerts you that they have purchased your alleged debt. But nowhere on this letter does it state where you have the opportunity to validate the debt. Violation off the rip, and straight to the attorney's desk it goes. So I said, like when I did, so basically saying, if you ever get a letter like this, send it to me, I'll get it reserved. I get it resolved. So I said, like what I did. Hold on. So that's the post, and that's me right there, the New Culture Empire. So I said, like what I did, thank you for your recent communication. We have reviewed our records and are ready to provide the following. We have closed your account and ceased collections. You have no further obligation regarding this account. Please contact customer support if you have any additional questions. That was Midland. So I said, y'all let these gurus get away with just talking without showing proof. None of y'all ask, where's his success at? Or for clients. All we know is there's going to be a fee. Not saying him, but many just go on Scrib, find old processes, and then sell it to y'all. I found 5 gurus posting a document that's easily, you can find it on Scrib. And this is what I mean, the laziness with these gurus. What really sets me apart is they're not going to do the deep, intensive research that I'm going to do. They're lazy. Want to know why? Because they don't have to. When people are just like, oh yeah, let's go. Why would they have to do any deep research when y'all not making them do it? When the student, y'all not making them do it. Yeah, you just believe anything they say. But then they come to me in the email complaining how they got scammed and they need help. And then they'll say, I don't have any money. Respectfully, I'm probably the last person you should reach out to then. So a person said, how did you do this? Person said, how did you do this? And I said, not with anything that you gurus online talking about. So someone keeps talking about the wet ink signature. See, those are buzzwords that people say. Anytime someone says wet ink signature, it lets me know they have no understanding of the system. It's just that fast. Because everything is electronically today. Like they could use electronic. Like why would they need the official system, official document when it's electronic? Hell, at some dealerships, you get a scan disc and your contract pulls up on the scan disc. Actually, for my wife's Mercedes-Benz, it's really bad. But they gave us a scan disc. No wet ink signature paper copies. It's a scan disc now. I mean, come on, y'all. Who's howling around all that paper? When you're asking for the original wet blue ink signature, you are, it's like you're back in the 1900s. We're in 2026. And just because there's no wet blue ink signature, it does not mean that the debt is over. Like and yo, when I say people got a long way to go, I mean people got a long way to go. And why do I say a long way to go? I only say that people got a long way to go. The only reason why I say that is because it's gonna take them years to uproot their beliefs. It's going to take them years. It's going to take them years to uproot the beliefs. And most people, they just don't want to admit that they're wrong. They don't want to admit that they're wrong. And where do you go from here? So where is it going for 2026 as I pull this video up? Where does it go in 2026? Now, I'm gonna be honest with you. Not even gonna lie to you. Not even gonna say it. Unless they have top elite litigation skills, unless they have top elite litigation skills, unless they have professionals on their teams, I truly believe that 2026 is going to end the same way it ended in 2025. I believe it's going to end the same way. 2026 for a lot of people is going to end the same way in 2025. I believe in 2026, the Supreme Elite team, the Supreme Elite Team University, you're going to have more people once they complete that university having wins than ever. By then, the first wave of these new consumer claims, because I'm spearheading the movement. No one is filing lawsuits like me. None of them. No pro says. I'm going to be look back 20 years from now as a person who spearheaded this new movement. And yes, there's going to be people that's going to be teaching from the literature that's in my Supreme Elite Team University. I'm going to be the new standard. Once they get more eyes on me, once people become familiar, I'm going to end up being the new standard in consumer litigation.
Petulance. So let's begin.
Okay. So this is case number 2401653 GC Cavalry SPV1 LLC versus Tarina Tarena Ingram.
Good afternoon, Your Honor. Jeff Warburg, 67124. We have
All right, Mr. Warburg, good afternoon. Ma'am, what is your name?
Hello, Your Honor, Tarena Ingram.
All right.
Thank
And
you.
good afternoon to you.
Good afternoon, and thank you for hearing this case.
No problem. All right.
No.
And so
I got a better one.
Hey guys, welcome back to the channel. Today
Tennessee pays for non-payment of rent.
Yes, Your Honor. I object to these proceedings moving forward because, like I said, I do have a verified.
Now, this is going to be a case. This right here is the epitome of what I'm talking about. We're going to start the new year off to remind y'all of what happens when you believe that everything you've learned is right. When you believe it. When you believe it and nobody can tell you different. And if the courts see it different, then the courts are wrong. Because that's what they want to tell you. These gurus that be losing for their clients, they always want to, oh, the courts was wrong. They're playing games. No, it's not about what the courts say. It's about what's right. What authority, what power do you have to override what the courts say? So this is the epitome of what the Supreme Elite Team University is going for. People that's in it, they're not going to have to go through this anymore.
on behalf of the plaintiff.
Ms. Battle, could you please state your name?
My name is Denise Battle.
Thank you so much, Ms. Battle. All right, today's the day and time scheduled for a hearing in this matter. This is an action to terminate the Tennessee pays for non-payment of rent.
Yes, Your Honor. I object to these proceedings moving. I do have a verified petition and emergency motion for injunction.
And I looked up that case. It was dismissed for failure to state a claim and frivolous filing. It was dismissed fast.
In the U.S. District Court, which is the case number 25-CV-11233.
Thank you, Ms. Battle.
And like I said, this court has not put on the record their jurisdiction. There's nothing on the record that stands. Every notice that I've sent is unrebutted, which stands at law. And jurisdiction is a threshold issue that we shouldn't even made it this far without discussing proper jurisdiction.
All right. Anything else, Ms. Battle?
All right, let me end this one for all, because I know people, that's what I'm saying. See, people, they research cases from the 18 and 1900s and really don't have an understanding of what they're talking about. So basically, when you challenge jurisdiction, I know y'all read it, jurisdiction could be challenged at any time, and the proceedings must stop until it's settled. I know people have a literal interpretation of what that means. So they think that all they got to do is come in court and say, I challenge jurisdiction, and the proceedings have to stop. And then the judge must show why they got jurisdiction. See, that's that literal lack of understanding of court, lack of understanding of court rules, how it goes. It doesn't go like that. Stop reading those 1905 cases thinking it's the same day in court. When you challenge jurisdiction, you must file a motion. You must supply a court with the motion. You must supply the other team with the other side with a copy of the motion. They get a chance to respond to the motion challenging jurisdiction. The court sets a hearing. Then you make your arguments on why the court doesn't have jurisdiction. That doesn't mean read your complaint into the record again. You argue key points of it. See, this is called, you're going to learn this in the Supreme Elite Team University. It's called court litigation. And then they're going to argue their points. And then the judge is going to rule on whether the court has jurisdiction or not. The biggest hurdles that all of you jurisdiction people going to can't get around is that the courts have jurisdiction, number one, based on the 10th Amendment. So all this common law court or admiralty courts. Admiralty courts are for crimes committed at the seas, the naval, the ocean. So take that out of your driving tickets, consumer law, being sued, civil court, criminal court. Take admiralty and throw it in the trash. I know your mindset and your belief don't want to do it, but the reality is put it there. It doesn't apply unless you're on the seas. Common law courts, there are no more common law courts like common law. All right, where's the common law section here? Common law is a doctrine where the courts can apply common law to give you equitable relief. There's no common law court. See, I got to get out of the old sovereign citizen, ancient way of thinking. It doesn't work like that. So once the judge rules theirs, in which they're going to, they are going to proceed. Every court that's situated in a district and where the claims are situated at, that court has jurisdiction. And let me let you in on a secret. They have it automatically. So if you're in Broward County and the dispute took place in Broward County, or the crime was committed in Broward County, but then they take you to Palms Beach, then you can challenge jurisdiction. But let me tell you this, they never get jurisdiction wrong. Wherever the court is situated in that location, that court has jurisdiction. That's why you go to that court. I'm in the 4th Circuit. I went to the Eastern District of Virginia where I'm at. I didn't go all the way down there in West Virginia. I went to the court that's situated where my dispute arises from. So y'all know when courts have jurisdiction when you file your complaints, but as soon as a complaint is filed against you, now the court must prove jurisdiction. But you want the court to grant you relief. So how can the court grant you relief when the court don't got jurisdiction anyway? See, when you're at the Supreme League Team University, you can stop playing these stupid games just because you want to get out of accountability, and then you can learn how to argue and fight the correct legal way.
As of right now, no. But I object to these proceedings in jurisdiction, subject matter, and personal.
All right, your objection is noted for the record. Ms. Battle, I've already ruled on jurisdiction when we were here last time. We will be proceeding today. The court does have jurisdiction.
You're rocking with the best.
Y'all know one of my key terms. If you don't want to listen to me, I'm going to let the judge tell you. Now you can argue the judge.
Mr. Fantira, and Ms. Battle, do either of you have...
I object. The court cannot declare its own.
And just because you disagree, see, this is where frustrated because my belief system is being challenged and I'm losing on my belief system now. See, anytime they do all that, it's because I've been studying this stuff. I've been studying it. I thought I was right. It should be right. The reality of she's been studying the wrong things the whole time is smack her in the face and they lash out because they can't accept reality.
If you keep interrupting me, ma'am, you're going to get held in contempt of court, and the court does have contempt powers, so throw you in jail.
I interrupted you. Okay, that's all.
Your Honor, I want to point out also that Judge Vandenberg actually addressed this issue last Wednesday in the 14B District Court, and Your Honor does have jurisdiction over this matter. So not that it needed to be.
May I add, Your Honor? Yeah. She also said that she was not aware of the things going on, so she just went on for anything based on what he just said. She had any laws nor facts, just as you don't, of why you have jurisdiction.
If the court truly had no jurisdiction, then why are you even there? That's the contradiction no one ever explains. If
I need battle parent specialist.
The
Be sworn. You swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing.
I do.
Four, I'd be moving for that to be admitted as plaintiff's exhibit.
Denise Battle appearance, especially not generally.
Thank you.
Denise Battle, what is it? Appearance, especially not generally. Once again, a special appearance is when the lawyer steps in court and you're not in court. Or one of your representatives or one of your family members comes in court because you're just not in court. That's what a special appearance is. When you're actually showing up as the plaintiff or defendant, by you saying, I'm here, special appearance, it automatically lets the court know that you're a sovereign citizen. You don't know what you're talking about. Because in order for there to be a special appearance, the primary party in the case cannot be there. She's there. There's no special appearance. But these are all part of the court rules, the stuff that you're going to learn with Supreme Team University. So you won't stop making fools out of yourselves in court.
All right, we're here for the continuation of the hearing today.
And I'm not going to keep stopping it. What makes the Supreme League Team University so powerful and so valuable is you'll stop coming with these claims in court just out of desperation because you're trying to save your property or your living situation or your vehicle. Even though that may be what you're trying to do, you'll have legal ways to argue it where it's already been respected in court and you got case law to substantiate yourself, so they're just not getting the immediate judgment. It goes to the next phase. And if anybody that understands court, the longer the case goes on, the more their cases get weak because they can see with us. So first, with the gurus, when they file the complaint and the evidence of indebtedness, 9 times out of 10, with y'all gurus, when y'all reach out to them, they're going to get summary judgment and you're going to lose. And then your guru going to take it on the pill. Then they're going to come online talking about the court playing games. See, with us, when they file the complaint with my clients or they file a complaint against you and they got the evidence and indebtedness, it still goes to pretrial. Meaning, even though they got the actual debt, they're still not getting the judgment.
Battle when you're not speaking.
You said, can I mute my mic when I'm not speaking?
Correct. Thank you. All right, Mr. Fantera, I believe that we are in the middle of your, well, actually it was Ms. Battles. Direct.
Yeah, I think Ms. Battle was cross-examining Ms. Charles.
That's correct. Ms. Battle, are you ready to proceed?
Yes. So Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to terms in writing?
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Meaning that there are waivers inside of the lease.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted.
Oh, by the way, when there's a lease, when they take you to court, when you go to court for like lease not paying, the only thing the courts want to hear, that only thing that's going to matter is, did you pay or not? They're not hearing all these securitization claims. In order for you to do that, you will have to file your claim against them in another court, not rental and landlord dispute courts. You got to take it in to the other court and then come in as the plaintiff. Unless you can show that you already paid. If you're trying to fight this and you know you haven't paid, 98% of the times you're going to lose because these courts are not hearing none of those other claims.
Last time, and it was admitted, Ms.
But you would already know that in the Supreme League Team University.
Battle did not object, so I don't know what she's asking right now when she talks about a waiver. She signed the lease.
Okay, that's fine. Are you aware of the notice of rescission that was sent?
Yes. I object. Rescission, she We can't go down this road again.
Why are we not going down?
Because it's not legal. You cannot unilaterally rescind. And let me get to this rescission of contract crap that I keep hearing. Like a mortgage. The only instances where rescission, and you got a limited time of doing it, is in cases of you're refinancing your home. You're getting a home equity line of credit, also known as a HELOC. It doesn't mean literally that you can rescind your mortgage and still keep the home. If you rescind the contract, which you're going to have to get a lawyer because they're not letting you out of it, that means you give the house back up. But let me guess, the only reason why you want to rescind, because you want to keep the property too. See, the Supreme Elite Team University, you will stop doing all these disingenuous things to get the outcomes that you want.
On the road.
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission. It's about, this is a non-payment of rent, pay and stay case. The question is, how much money does she owe in order to stay in her lease? She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proved.
What did I just say, y'all? What did I just say? They actually think like a common law. It's like a tangible, like common law court. It's based on common law. Common law is only applied by the judge to give people equitable relief. Common law, now look at her face. Common law is not, you don't apply common law in your own right. The judge, see, you're going to learn this in the Supreme Elite Team University.
Proven or stated any laws or facts that back what you're saying. Unlike me, I have.
Yeah, but you stated them all wrong. And one of the things you stated was the Magna Carta, which was from the 12th century in England.
And once again, you're going to learn legal, coherent, up-to-date, relevant case law. You're not going to go back to treaties and doctrines to prove your case. You're actually going to have case law, one of the things that none of these gurus can never provide to y'all.
No, I stated it under common law and landlord-tenant acts.
That's not, we're not under common law anymore, ma'am, and that's.
If you don't want to hear it from me, hear it from the judge. I said, we're not under common law anymore. There's no common law court. It's just a doctrine that's applied in certain cases to grant equitable relief. So since you don't want to hear from me, hear it from the judge. I find it very odd, very interesting that a lot of the judges be saying the same things I'm saying. And then you wonder why none of my clients, they're getting hit with a judgment as soon as I step in the picture. Oh, it's not hard to wonder why.
Please
and
stop.
landlord-tenant acts.
That's not, we're not under common law anymore, ma'am. And that's a part of the problem with sovereign citizens. They think they know the law when they don't.
And you're always going to be labeled a sovereign citizen when you come in and talk about, is this a common law court or average jurisdiction? Oh, I'm not sovereign citizen. Yeah, but people from 40 years ago came in court saying the same thing, and they'll raise their hands telling the courts they're sovereign citizens. So why should we not look at you any different? Damn, I didn't even do my research on the origins of what I'm arguing. That's the problem. Y'all get mad when people call y'all sovereign citizens, but the people who was like, I'm a sovereign citizen 20, 30, 40 years ago, they was coming into court saying the same things, but they didn't hide away from being a sovereign citizen. The only reason why you don't want to be called sovereign citizen, because you know it has a bad look and a bad name, but you're making all the same arguments that they did in 2025. But you expect them to, oh no, these are the same arguments. It looks like a duck, talks like a duck, quacks like a duck, but I'm not going to treat you like I'm not. No, you're not a sovereign citizen because you say you're not, but your documents reflect it. And people can't even understand that. So you think they're going to get remedy in 2026? They will argue me down on that.
That is
Well,
not.
that sounds prejudiced and biased because I'm not a sovereign citizen. So it seems like you're trying to group me in with them, and that I am not.
No, your arguments, your documents, everything that you say, everything that you cite, everyone from 30, 40 years ago, they already did and said the same things. And this is the part where they hate. They hate when I say that. You know, everything that you posted in my comments, everything that you said, you know, they said that 40 years ago was denied. It's like a gut punch. Hold on, you mean to tell me that I just figured this shit out? And you mean to tell me it's all old and outdated? Yes.
Well, whatever you're using as your basis is still not correct. It is not the law.
It is. It's still under MCL and it's under the Landlord Tenant Act.
Overruled.
My objection is overruled, Your Honor.
No, the objection is sustained. Her question that cannot be asked.
So you're saying I can't ask about the contract that's in question?
No, I'm saying that you have no basis for asking whether the contract was rescinded or not.
Why would I not?
It's a difference between the basis of what you think and a legal basis. Another thing you're going to learn in the Supreme University.
I have basis for asking if the contract was rescinded.
That's not the law. You don't get to unilaterally rescind anything, ma'am.
Well, again, as I stated.
My ruling, I'm not arguing with you anymore about it.
Right. It's not an argument. So just let the record show that there is no law or basis to what she's saying.
And all you people that always want to get something on the record, you're putting garbage on the record anyway. The record doesn't help you. I want to get it on the record for what? Everything that you're about to put on the record was already denied 40 years ago. So what do you really want to put on the record besides garbage and waste everybody's time?
And she has not yet stated any law or fact behind this objection.
Because it's the judge doesn't have to give you a reason why they objected. The judge doesn't have to give you a reason why they deny your motion. They just can deny it. You always want the judge to explain why they don't agree with you because you believe that you're right and the judge's supposed to see it your way. Can you imagine a lawyer, a licensed attorney questioning the judge why they denied their objection or denied their motions? They would get sanctioned. And that's what the Supreme Elite Team University is going to teach you how to do, how to operate like a licensed attorney. Something that 99% of you pro se people out there that's going to listen to this have no clue on how court works.
Asking these questions. I will continue. I will continue. Okay. Did you write me a notice to quit filing this action?
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession.
A demand for possession, yes.
No, a notice to quit.
No.
Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. Ms. Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Ms. Battle wants to use the wrong term, she's going to get the wrong answer.
And this is another thing with Supreme Elite Team University. You're going to learn the proper terms of how to use them correctly. I mean, that's every attorney knows that. But she doesn't know it because she doesn't have the understanding. She doesn't have the background. She doesn't have the experience. So like this shouldn't even be a conversation. Like if I was in a that would never be, because I would already have known that.
The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Because Ms. Battle didn't read the statutes. She didn't read it all to catch the context because she's so busy citing common law and 1800 stuff that you'll be surprised at how many pro se litigants never, ever study the court rules and procedures before they proceed in court. They be making so many procedural errors that I'm like, how the hell you ain't do that? How the hell you ain't know that? Because court rules and procedures, they're very long, they're lengthy, and most people are mentally lazy.
Is there proof of service? Is there proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You cited a statute that I actually need to look at. MCL what?
I'm sorry?
What was the statute that you cited?
MCL 657.6.
Another client we have to get on the meeting tomorrow because we're moving for summary judgment because they filed the complaint. Judge didn't grant it. Scheduled a pretrial, set a date for discovery and stuff. So this is the time where it's right for us to move for summary judgment. A position that 99.99% of your gurus can never put y'all in. So another thing you're going to learn at Supreme League Team University.
I mean, not 57.6, 600.5716.
Yeah.
Yeah, have you read that statute?
No, because they never read them. They never read all the statutes that apply to their case. They may read one, and they're so laser focused on that one argument. They may read that one statute for that one argument, but they never read in the statutes in its whole to get its context. And the Supreme League Team University, you're going to get trained in that mindset of reading it all and catching the context instead of reading it literally what it says.
Yes, I had read it when I first did this.
It uses the term demand for possession.
Okay, everybody please stop typing. It says a demand for possession or payment shall be in writing, addressed to the person in possession, and shall give the address or other brief description of the premises.
Can you imagine how bad I would look if I was putting complaints together like hers, and I'm training my students to go into court and argue, and I'm training them like that? Oh, I would be ashamed. Oh, that's horrible.
It's a demand for possession, not a notice to quit.
Okay, so is there proof of service of it on the record?
That's a different question, though. So, okay, go ahead.
But that's the question I asked next. Once he said that the
But I
demand
wanted
for possession,
to clarify your question before.
I appreciate it.
All right, Ms. Charles, please add her question next. Is there proof?
Do you have a proof of delivery or service for that demand for possession?
Nope.
Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object.
Oh my God. Every legal motion or document filed at the bottom is supposed to be certificate of service. A document and my client's documents because the court rule says you have to. Did you actually read the whole page?
She's now, again, she's not using the statute changed.
And that's one of the things that you're going to learn with the Supreme League Team University, how to stay up to date with relevant statutes. So y'all stop citing outdated statutes like the March 9th, 1933 Emergency Banking Act, with the emergency provisions regarding that act ended in 1978. So y'all stop citing the emergency provisions in that act that already ended in 1978. You know, you'll be up to date. Proclamation 2439, banking this. See, y'all will stop making those old, ancient, outdated arguments, and you can get up to date with the system with your arguments. Supreme League Team University.
So that you now need, on a demand for possession, a certificate of service.
You're rocking with the best. You're rocking with the.
Well, gee, Lamont, how did you know that? Because I follow the court rules.
And that's what's at the bottom of the page. If she's looking for a proof of service, the statute changed 10 years ago so that you now need, on a demand for possession, a certificate of service. And that's what's at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, she's going to get the wrong answer again.
See, my clients, when I put their most of the documents together, see, they don't have to worry about none of this. See, we already going to have all that stuff covered. You ain't got to worry about none of this. I mean, this is horrible.
Term is certificate of service, and I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom of the demand. So I would appreciate if she's going to cite statutes, she cites them correctly.
Okay. That's fine. I didn't cite an exact statute, but I appreciate your objection. I just said MCL because they're both under MCLs. Both proof of service and certificate of service are both under MCL.
No.
Right, everybody.
Hey, David Fantera, I know how you feel. It's so frustrated dealing with pro se people, and I get on the phone with them and they act like they know what they're talking about, and I be like, man, that's not how court works. Like the court, everything that you're saying to me right now, the court rules already says that you can't do it. And this is the problem, sir or ma'am. Yeah, gotta stop coming into court based on how you want to do it, what you believe, and then expect outcomes. Like you're not even following the rule. You don't even know what the rules are to the games that you're playing. But these are grown adults. And let me ask yourself a question. Why do so many people come to the most complex, nuanced settings to get any type of results unless they was told it's something quick, free, fast, and all you had to do is just submit this document and template and you're going to get what you want? What if they never told you there was no secret trust fund account? What if they never told you you just follow this template, it's going to work? Would you still be in these spaces? The answer for 99% will be no.
Can I make my ruling?
Let's just okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service is not on the disposition. And just like she read on 657-16, was the property described on that disposition?
This is not a, never mind.
Yeah.
Was there a description of the property?
Yes.
If there was a description of the property?
Correct.
On my copy, there is no description of the property.
This is what I mean.
But let's continue. Does your company participate in HUD programs or accept federal HUD assistance?
None of that has anything to do with the non-payment of rent. But go ahead.
Yes.
Okay. Did you provide me with grievance procedures required by HUD?
You're not under HUD.
Did I provide you with what?
Grievance procedures required by HUD.
Your Honor, I object. That's irrelevant. There are no such grievance procedures under this, anything that I'm aware of. I mean, I don't even know what she has a grievance about.
Right. The grievance would be with the breach, and you all have a grievance, and hence on why you initiated a hearing for the breach of the contract.
Never mind.
So it goes back to HUD because you're publicly funded, right?
No, we're not.
No, we're not publicly.
Well, you accept HUD housing. You accept HUD housing, and you apply, and you are in compliance with HUD laws and policies, correct?
Yes.
Right. Okay. So if you have HUD terms and you're
Your Honor, I object. Miss Battle is taking.
Object to what? I didn't say anything yet.
Well, I'm objecting because she asked Ms. Charles a question, which was, do you get any funding from HUD? Yeah, most companies do. We do. And then she takes that and starts taking that to a next question where it says, well, when you get funding from HUD, and then she's assuming.
I didn't assume it.
AKA, you're making legal conclusions, which is a no-no in court or in your motions. You cannot have threadbare recitals or make legal conclusions. This is the same things that would get 99 and has gotten 99.99% of pro se litigants cases thrown out or dismissed under Rule 12b-6, making threadbare recitals of the facts, making legal conclusions. But I'm pretty sure your gurus taught you about the standards on how to plead so it won't get thrown out at the beginning. I'm pretty sure they teach y'all these things.
Anything, I asked the question.
Okay, what was the question you were going to ask?
I said, do you have followed HUD's policies? That was my next question.
And she said yes.
Right, and then you objected after that.
No, and then you started the next question.
No, I started the question, but I didn't get it out my mouth before you objected me.
Let her ask the next question, and if you have an objection, I can hear it after she finishes her question.
Okay. Are you aware that before you initiate a hearing in court or the administrative process before court, you have to have an administrative hearing by a HUD administrative judge?
Your Honor, I object. I'm not aware of any.
Say no. I mean, that's
Just say no because you're not aware, and that's okay to not be aware. That just means that you are not aware of the laws that govern.
No, it doesn't, because it's not. That is not the law, ma'am.
How is it? Okay. Are you aware of the requirement under 42 USC 1437 DK for federally funding or accepted landlords to resolve disputes through HUD before an eviction proceeding?
You're not under HUD.
Again, I'm going to object. The fact that Ms. Charles answered the question about having a relationship with HUD doesn't mean we are a federally funded property.
I didn't say that you were federally funded. So let's be clear. I said either federally funded or get federal funds, which you do if you accept Section 8 and vouchers.
No, that's not true.
Why is it not correct? You had to think about it. Yes, it is correct. Because if you received any type of funds from HUD, which is through Section 8 vouchers or regular vouchers, you get what I'm saying? You receive funding from HUD.
We are. Do you?
I'm not saying that you're funded and that they give you loans of that nature. I am saying that you are within their practice and policies of HUD guidelines because you accept HUD in Section 8.
Your Honor, I object to this whole line of questioning. Ms. Battle does not receive a voucher, and so this questioning.
Well, it doesn't matter.
It does matter. You don't have HUD. You didn't get a voucher. HUD. What are you getting at with it? And this is what the Supreme League Team, this is what you're going to learn to not make asses out of yourselves in court.
Matter if I receive a voucher, it matters that you are that type of entity that needs to go through HUD because you
not if you're not a HUD participant.
Accept those things. So you agree with those terms and policies of HUD.
Your Honor, she's making that up again.
I'm not making that up. If you're saying that, how am I making it up? It's under 42 USC 1437 DK.
Battle.
It's a federal registrar on it.
Ms. Battle, you've made your record. My ruling is still that every entity that has to file a landlord-tenant action does not have to go through that process to collect rent, ma'am. That is not how it works.
Okay. Okay. You're saying that it doesn't have to, but HUD says that these are the requirements, hence why MCL at the bottom is.
This is why Supreme League Team University, you'll realize what are legal arguments, what are arguments in your best interest, or what are arguments that mean nothing. So we stay away from it. Don't even waste time on them. See, what these gurus I have y'all do, just throw everything at the wall. Us, we are precision point with our arguments. Bam there, bam there, bam there, bam there. Shut up.
Trying to align with HUD guidelines on the same registrar that I'm talking about. You have those codes at the bottom that match up with HUD.
Move on.
Okay. So obviously, if I can't really get a line of questioning, I'm being objected because he feels it's not right. He is objecting with no laws or facts behind anything he's saying. He's just thinking it off the top of his head. I'm not getting a fair hearing here.
Ms. Battle, move on.
Move on to, okay.
The judge knows she's been wrong since the time she opened her mouth. But she has to be, gotta let her get, and that's the thing. They gotta let them get the babble out.
Do you have a copy of the court establishing jurisdiction?
Who's that a question for?
Dawn, my plaintiff.
Your Honor, I object. The court's already said they have jurisdiction over the property.
The court said that she had jurisdiction because she said so, and that's non-judicial.
This is what I mean. Supremely to University. This is why I'm making my pitch. Bam, right there.
Okay, Ms. Battle, move on.
Move on to what? If I cannot have, this is not a fair hearing. And again, this is why
you're trying to turn this into.
I'm not trying to turn it into anything. I'm just trying to state the laws, and I'm not trying to argue with y'all about anything. You get what I'm saying? I'm not trying to argue with y'all. I'm just trying to get y'all to state and prove y'all facts, and y'all have not proven any facts. But for some reason are hindering me in this proceeding. And that's why I took this case to the U.S. District Court in Eastern.
Got thrown right out.
That's why there's an open case right now with all you all, because this is just not, and I told the Attorney General, and I told the IRS, and I did everything else, because at the end of the day,
please move on.
This is not right. And Attorney
I'm going to be filing criminal proceedings against you for all these frivolous things that you're filing against me. So
if you feel that it's frivolous, that's fine, but it's not. My rights are not frivolous. It's if I can't have a fair hearing, nobody has any facts. Y'all talked about constructive possession. Nobody wants to talk about that. Y'all keep saying that I rescinded a contract unilaterally. That's not the case. It's called notice. And when a notice goes unrebutted, just like if I was to come here, if I was to get that notice of dispossession and get a notice of a hearing, and I missed that hearing because I did not rebut, that would constitute as
cross-examination. If you're not going to ask appropriate questions, then I'm just going to silence you. So you get the opportunity to ask your questions, or you can just be silenced.
I don't have a real opportunity to ask the questions. So at this point, like I said, I'm just going to have to get the federal court involved and get the marshals, because I don't know what you all are going to do. You all have not been acting in honor and with good faith. So I don't know. I'm stuck on what to do. The integrity of the court is questioned.
With you, I don't know what that is, but you should seek some mental health. There's something.
I'm sorry.
I second that.
What's wrong with you? You have you have a mental problem.
I have a mental problem. How?
The United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world. There's clearly something wrong with you.
No, Your Honor. All these sovereign citizen people, all these people in these spaces, they ain't never got shit accomplished. All these students that don't know shit from apple butter. All these gurus that's losing their case left and right, but they hide it from their students, but not know me. I'm a docket junkie, so I'm always checking the docket on their cases, and they're getting them thrown out left and right. They all think they know more than everybody else. They all think they know more than the judge. They all think it. They all do, Your Honor. You're not the only. Yeah, I mean, I've been trying to tell people all the time. Same thing you're saying to her. I try to tell people all the time. I think there's something seriously wrong with people in these spaces, with the sovereign citizen community, or the fact that you can tender a check that you went to fucking Kinko's or FedEx and typed up yourself and send that to a title company to say payable through the Treasury, and expect the Treasury is going to send $1.7 million to buy you a home. There's something wrong with you. If you think that you can take a money order, scratch off $1, write $27,000 on it, and say, here's payment. There is something wrong with you. There's something wrong with these people. For real. If you think you're going to buy goods and services without real money, there's something wrong with you. If you think you're just going to send in a document that's a general template where 500 other people got the same thing, and all 500 people are going to get let off there. There is something wrong with these people.
Now, what did I make up?
All of it.
What? Be specific. No, be specific, because now you're lying on the record. This is perjury. I didn't make nothing up. 42 USC definitely applies to this case.
All right.
Jurisdiction is a threshold.
Ma'am, if you don't stop, I'm going to remove you from the court proceeding. So, Mr. Fantera, apparently we're not going to have a reasonable hearing here today because Ms. Battle feels as though the laws are very different for her as opposed to everybody else in the world. I'm not certain how to handle this going forward. You have submitted your documentation and she wants to argue stuff that's not law, regardless of my rulings. So therefore, I'm not sure what to do with respect to your case.
I would ask for a directed verdict. She hasn't said anything that is a defense to my action. And I submitted a proposed judgment this morning.
Oh, here's another thing you're going to learn at Supreme Elite Team University. When you file your motions and your counterclaims and suits, and when you move for your own summary judgment, hey, how about attach your own proposed order? I'm the only one that does it. I already talked to members in my group. They've been around these spaces. I'm the only one that does it. These gurus, they don't even have the wherewithal enough to understand the rules to attach a proposed order to it. Can you imagine what these social media gurus' proposed orders would look like when they're requesting relief in a proposed order so the judge can sign it when they grant the motion? Can you imagine what their proposed orders are going to consist of? A whole bunch of bullshit.
There's rent owing in the amount of $3,432.42, court costs of $177 for a total of $3609.42. We would ask for a judgment for possession with a writ after 10 days, and she can avail herself of whatever procedures she can in another court.
So you're saying that none of my objections is valid towards your claim. So having a valid contract is not an objection. Oh, because you're saying that because a notice was given and unrebutted, it's not of law.
You can send a notice to the Pope. Just because they don't respond to the notice does not mean it stands as true. Just because they don't respond to an affidavit, it does not mean it stands as true. When you are in a legal setting, notices and affidavits do not govern when the other party has to respond. Motions and pleadings govern when other parties have to respond. An affidavit is attached to the motion just like a memorandum. The memorandum of law, points, and authorities are what lays out the whole basis for the motion. The motion is just saying, for all the reasons stated there, giving a quick summary of the case and asking for relief. The proposed order is requesting basically the judge, if they rule in your favor, the proposed order is just the judge just signs it, granting the relief requested that's in the motion. That's called court procedure.
Best. You're rocking with the best.
That's
what you're
not,
saying, right?
yes, that's not the law.
It is. It's the law. It's versus Zendaya of Michigan. It is.
That case law had nothing to do with the argument you're making. I looked it up. It's so.
It's
All right.
fact and case law. And y'all keep muting me. It's okay. Because he can talk, but I can't talk.
Ma'am, you've argued that over and over, and I've ruled that it's not. You can file your appeals, file all the things you're filing, but when you file false liens against people, that is a crime.
It's not a false lien. You got defaulted on a private side, and you know that.
Defaulted on the private side. What did Kenyatta do when she felt like she was losing and she was mad because all of her teachers blew up in her face? What did she do? She filed a false UCC1 lien. What do all these sovereign citizens do when they get mad that their sovereign citizen beliefs and arguments are not winning? What do? They file false liens. See, with the Supreme Elite Team University, you will have no need to file a false lien because you're going to be arguing your case from a legal, coherent, and competent standpoint where not only the judge respects, but the other side respects. Something that 99.99999999999% of people in these spaces can do. I am the 1%. The Supreme Elite Team is the 1%.
Okay, whatever. All right,
Yeah,
so
okay.
what I'm going to do is grant your judgment in this particular case because I've given her an opportunity to present defenses that are real, and she has refused to do that.
I didn't refuse to present defenses. You didn't ask me about my piece of the case. I only got to cross-examine. You didn't ask me about my defenses.
What are your defenses, ma'am? In
Here we go.
rescission is not one. I've ruled that it's not.
I'm sorry?
I know you heard me.
No, I didn't. You said, what are your defenses? And I didn't hear the last piece.
Your rescission is not a defense.
Okay, that's fine.
That is your defense.
Right, because, you know, threshold matters are not an issue. But again, like I said, the fundamental objections and a counterclaim, object to the subject matter jurisdiction. You all accept and receive housing funds, making the subject
We're
matter.
going down the same road.
Okay, listen, stop. I didn't cut you off. I didn't cut you off. You just asked me what my defense was. And
all right, I'm done.
Wow. You're asking me what my defense is. I can't.
Take her out. I've asked her 3 times to stop this. All right, I'm going to grant your judgment in this particular case.
Your Honor, are you going to check the box after hearing?
Yes.
Thank you.
Thank you.
You're rocking with the best.
And although these gurus may not, well, I haven't seen them in court, in which my next video, you're going to actually see me in court, how I operate in court. Something these gurus don't ever want y'all to see how they operate in court, by the way. But a lot of these gurus, they have the same mentality when they lose cases for their clients and they got to file an appeal. Oh, they didn't answer exactly what I said, because they discredit you on the rules and procedure. Oh, I don't care if the courts never do that. It's not what's right. Can you imagine me handling top cases for a lot of people, like their livelihoods are on the line, and I'm saying I don't care if the judge didn't grant it or didn't see my argument my way, I don't care what they say. It's about what's right. Can you imagine how I would look trying to explain that? Like, can you imagine? But I've seen gurus do it all the time. They'll come right on there talking about, it don't matter. It won't matter if they denied it. It's what's right. Supreme Elite Team University. Registration is open now. Thomas Legacy 603 at gmail.com. Hold on. How many people we got since this live started? We got 3 so far. Good shit, boy. Good shit. Y'all will be getting the curriculum tomorrow to let you know what the whole, semester will be hitting on. Registration ends January 31st. First official class starts February 26th. Before the official class starts, I have a lot of pre-recorded videos that I'm going to be dropping in the Supreme Elite Team University group, so y'all can just become aware of what's going to be going on, seeing videos, check, get yourself in order. It's going to cover mortgage, autos, credit cards, anything financing, court rules and that, what the points of attack. These are going to just be videos and stuff, and so y'all can just get in tune, get yourselves in order. This is not just for the people that's in the group. Y'all can use this to help out your family members and friends. As you've seen at the beginning of the video, how a member of the group was able to help assist his friend with his case. And guess what? His friend, they about to win the case. A big bank. See, with Supreme Elite Team University, we take down big corporations on a daily basis. We shut them down on a daily basis. No need to say more. Y'all seen the receipts. Y'all know what I'm hitting on. Y'all know what we talking about. I got more. I just don't decide to post them, but I will. But y'all know what it is, man. Supreme Elite Team University, the new culture empire on all platforms. Check me out. I know y'all watch. I know most people not going to like, but y'all, one thing you can't say is I'm wrong. As a matter of fact, pocket watching with JT. You see, he stayed away from me. I'm right. Everybody else is wrong. You're going to do it the way I say, or you're going to lose in 2026. Straight up. Straight up. You're either going to do it the way I say, or you're going to lose in 2026. Straight up. This lawsuit against Credit Acceptance Corporation isn't just about one contract. It's about exposing a nationwide scheme that's been hiding in plain sight. Credit Acceptance structured my agreement to look like a simple car loan, but behind the scenes, they securitized it, retained control, and charged a 23.99% interest rate, well above Virginia's legal limit. That's not just deceptive, it's unlawful, and they're doing that in every state they operate in. If Virginia steps in this case, could trigger a wave of enforcement against lenders who use dealer advance programs to disguise true lending relationships. And if the federal government follows through, the IRS, CFPB, or SEC, then consumer lenders across the country will be forced to rethink how they structure, report, and enforce their contracts. This lawsuit demands restitution, recharacterization, and accountability. But more than that, it could set precedents, forcing leaders to respect substance over form and putting consumers back in control of their financial rights. The system's been rigged long enough. Now it is actually time to expose it accurately. And the claims that I'm raising in my lawsuit are the same claims that Credit Acceptance has settled numerous of times with investors, other consumers, or state attorney generals who actually stepped up and held them accountable. This lawsuit is the first lawsuit in the history of the Fourth Circuit and all other federal circuits where claims of this magnitude has been brought against Credit Acceptance Corporation or any other finance corporation from a consumer capacity. You normally see these lawsuits filed by attorney generals of states or the lawyers for the investors. Never have you seen these claims filed from a consumer standpoint. I've seen a lot of consumer complaints and lawsuits filed against Credit Acceptance and other finance companies, but they all have missed the mark because they are approaching it and attacking it from a consumer-like standpoint and doesn't have the mindset of a creditor or a lender to attack them on the level in which they operate. This lawsuit could actually spark a reform in consumer financing. I am one man taking on the complex system. So, it further goes to says that this is what took place, man. I signed the contract. The dealership transferred that contract to Credit Acceptance. Credit Acceptance now had the proper collateral so they can issue trust notes to the investors. The investors put the money up for my deal, for the purchase price in exchange for the contract in which where I will be making my monthly payments. Cool. No issue with that. The thing is, and your legal department admitted that Credit Acceptance never gave me any type of funding in order to even support a contract, which is not a big deal. Rather, they got my promise to pay the security and they was able to raise the funds for the purchase. So is it that credit, and this is their own words, I'm reading from and it's filed with the SEC. So is it more that Credit Acceptance really just acted as a broker between me, the one that needed financing, and the ones who's willing to invest in my contract? So you all just kind of mainly were just the middleman to broker the deal instead of really being a lender in the traditional sense, like Credit Acceptance went into their own back pocket and put up the money. You kind of more brokered the transaction. Is that more of an accurate statement? Well, I'll be damned.
Reminiscing the good old days, remembering to forget all the bad ones. I remember when college seemed so important, but is it worth it? Been wondering what truly matters to me. I know for sure it's not a fancy degree. I'd like to do what I love, but what if I'm not good enough? Split personality, sometimes sour, sometimes sweet. An M. Night Shyamalan story called Everything's Peachy. Can we just skip straight to the plot twist, please? Life's all about balance.